Hello friends, in the series on the income tax cases, today we will discuss the case of Principal CIT versus Sanjay Dhingra. This case has been reported in 457 ITR, page number 588, and the matter has been decided by Honorable Calcutta High Court, and the date of the judgment is 22nd November 2022. This case is regarding imposing of penalty under section 271 AA(b). The penalty under section 271 AA(b) is regarding penalty in cases of search. As all we know that penalties are not automatic, and in most of the cases there is a section 273B which is for the rescue of the assessee, and according to that section, if the instances which are mentioned in section 273B, if the assessee proves that there is a reasonable cause, then in that case the penalty becomes discretionary, and the assessing officer and the higher appellate authorities can delete the penalty. But the beauty of that section is that in section 273B, a number of the sections are there, but section 271 AA(b) is not there. Meaning thereby that the assessee do not have the option of showing reasonable cause in cases where the penalty is imposed under section 271 AA(b). This was the first issue in this case. And the second issue in this case was that the ITAT deleted the penalty imposed on the assessee by the learned assessing officer by relying on its own judgment in a case where the department was not able to appeal before the High Court just because of the reason that that case was not qualifying the monetary limits for filing the appeals in the High Court. Meaning thereby that the ITAT relied on a judgment which was not taken to the High Court only because of the merits, but only because of the monetary limits. The High Court said that the ITAT has not demonstrated in the order that how the decision relied by the ITAT would apply in the case of the assessee, or in other words, there was no discussion by the ITAT on the factual aspect. Calcutta High Court also said that one case was relied on by the department. In this case, the name of the case was Sandeep Chandok versus Principal CIT, which is there or which is cited as 405 ITR ST 11. The High Court said that the ITAT has not demonstrated that why the case relied on by the department is not applicable to the case of the assessee. Calcutta High Court also said that the ITAT has failed to show how factually the case relied on by the department is distinguishable in the case of the assessee. So on these three grounds, the first ground, that section 271 AA(b) does not appear in section 273B, which talks about the reasonable cause. The second point, the case relied on by the ITAT in favor of the assessee was not on merits, it was only because of the monetary limits. Thirdly, the judgment relied on by the department was not taken care by the ITAT while deciding the case. Friends, this case is very important as far as the understanding of penalty provisions in case of search, that is section 271 AA(b), and for the escape route for the assessee through section 273B in the cases where the penalty is initiated or imposed by the department on the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal CIT versus Sanjay Dhingra, and this case has been reported in 450 7 ITR at page number 588. The matter has been decided by Calcutta High Court and the date of the judgment is 22nd November 2022. Thank you, friends.